So good morning, everybody. Thanks for joining us. This is Cassandra Steppen from the Minnesota Department of Health, Tobacco Prevention and Control Program. We definitely appreciate you coming to us last minute here, meeting with us this morning as we're getting going on some of this sorting out of our two new federal laws. So today, the purpose of today's call is for OSHI to communicate directly with our funded partners. The information shared here is not necessarily intended for licensing authorities, retailers, and law enforcement, nor is it MDH's jurisdiction. Our intent is to relay information that we have learned through our state and national partners to better understand the new laws and timeline to best inform our work. We also want to relay that without a lot of published FDA guidance on these new laws yet, we are conveying what we know today. As new information is released, we will use the same communication methods to relay that information to the best of our ability. Again, because MDH is not the agency charged with implementing these new laws, we may need to take questions back to our partners and hopefully provide answers then at a later time. But before we get too far, I just want to inform you that this call is being recorded and a link will be posted to Basecamp. There will be a few visuals shown, as you can see on the screen. If you are participating by phone only, these will be shared with a recording on Basecamp. Lastly, all participants have been muted when you enter the webinar. This helps reduce our background noise. We ask that all remain on mute until we open it up to the general Q&A portion of the call. At that time, we'll ask you to raise your hand or put the question in the chat box, and we will call on you for the questions. For those on the phone, you can go ahead and pipe in when you do have a question during a transition moment here. So I am happy to introduce the Public Health Law Center. As most of you are aware, they are a legal and policy technical assistance provider for MDH and our funded partners. As well as their state work, they are also providers for other national entities, are in a great place to help us sort through many of our questions. They will get us started here today with a brief overview of the new laws. They will walk us through some frequently asked questions that we've collected over the last few weeks. And then we will open up the lines for more questions from the participants. I got a message here that there's some sound issues.
Yes, we are figuring that out. It seems like some people can hear over the computer, but some people are learning that they need to call in.
Yep.
We're looking into this. Stephanie?
I'll do a chat, but everyone should make sure that they join the audio portion of the Zoom meeting. So I'll send it via chat, the instructions how to do that, but you do have to click on join audio and then join with the computer audio. So I'll send a chat to everybody to make sure that they can log in and join.
Mm-hmm. Okay, great. And so if you're hearing, well, I guess if you're not hearing this and there's no sound, that doesn't help, but you can join by call only. So just make sure that they know that.
Yeah. We'll put that in the chat box, but thank you, Cassandra, for the introduction. Everyone, this is Natasha Phelps. I am the lead senior staff attorney for Minnesota Technical Assistance. We have, Stephanie, if you could just do the next slide. Just to build off what Cassandra already said about the Public Health Law Center as a TA provider for the Minnesota Department of Health, if you can see, if you've joined on the computer and you are looking at the screen, you'll see our team of attorneys. And there are 4 people whose faces are circled. These are the people, the attorneys who primarily work, 5 people, thank you, Natalie. These are the 5 people who primarily work on Minnesota. And so we are here to help with any TA that you have regarding local ordinances, enforcing of those ordinances, et cetera. So feel free to contact us after this call, especially if you have any remaining questions after Natalie's overview and the question and answer portion. But we hope today that most, if not all, of your questions will be answered. I'm now going to turn it over to Natalie to first go over the federal flavored action and then talk about the T21 legislation. Natalie?
Hi, everyone. So I am a staff attorney here at the Public Health Law Center, and I actually split my time between working on issues, federal issues, FDA, with our FDA team, and then I also do local Minnesota work, so you might recognize my name from working with me in the past in that capacity. Most of the questions we have been getting have been around Tobacco 21, but I'm going to sort of give you an overview of the flavor stuff first so that we have plenty of time to really dive into any of the questions you have about either topic. So the FDA took action banning the sale of some flavors and some e-cigarettes recently. So in short, manufacturers are no longer allowed to distribute or sell pod or cartridge-based e-liquids unless they are unflavored or they are only flavored with menthol or tobacco. That means that fruit, dessert flavors, mint flavors, wintergreen flavors, those are all included and cannot be sold if they're cartridge-based e-liquids. This was issued January 2nd. It was published in the Federal Register January 7th. And after January 7th, there will be like a 30-day window that will allow retailers to sell off and manufacturers to sell off their remaining products. And then after that, no more sales can be made. This does not directly impact local licensing ordinances. However, because of the problems I will get to in a little bit, is opportunities for cities, states, territories, and tribes to fill the gaps and pass ordinances that will actually be effective at addressing the harms associated with flavored tobacco products. The first issue to bring up, and the foremost issue to bring up, is that, as I mentioned before, the administration exempted menthol flavors, and that flies in the face of the mountains of evidence that support the removal of menthol from all tobacco products, and specifically disregards the immense public health benefit for African American community, the LGBTQ community, and other targeted communities. The choice to exempt menthol perpetuates health disparities for these communities, and the evidence overwhelmingly supports prohibiting menthol as a flavor to protect public health. The second issue with this action that FDA took is it's inherently temporary. Because of the mechanism the FDA is using, the manufacturers only have to remove their product until they apply for and receive authorization from the FDA to re-enter the market. So basically, after the 30-day sell-off period, manufacturers will remove all of those fruit and dessert and mint cartridges and e-liquids, and the process will be for them to fill out an application with the FDA and submit it, and then the FDA will either deny or authorize their application. And if they authorize their application, those products will just come right back onto the market. So it's just temporary until they go through that process that they're required to do. The other problem is that it doesn't apply to a lot of types of e-cigarettes. So it only applies to pod or cartridge-based systems. And so that allows these flavors to be sold in tank or mod systems. Those are systems that are generally sold at vape shops or in products that are completely self-contained and disposable. So there's several of those flavored products on the market as well. And it is leaving a lot of products that we know are some of the most popular rising products among youth, and these attractive flavors in kid-accessible ways. So that's concerning. And then the other issue is that besides not covering all e-cigarettes, it also leaves harmful flavored combustible products on the market and easily accessible to kids. Little cigars come in a variety of flavors and are often sold in small quantities, making them appealing to youth and a natural product for youth to take up to feed their nicotine addiction. So the FDA had the opportunity and initially had suggested that they would address flavors in combustible products as well, and they did not. So it's left a lot on the table and a lot of products that are still appealing, addictive, and harmful to youth. We know that flavors are one of the main contributors to the youth e-cigarette epidemic, and youth routinely say that they're attracted to the products because of the cool flavors that they offer. The FDA's weak action should not keep localities from moving forward with flavor restrictions for all the reasons I've already described. Instead, local flavor restrictions are likely to fill these gaps left by the FDA in a more comprehensive and long-term way. If any community would like to adopt a flavor restriction, we have model language and are happy to help with that. I'm not diving deeply into the nitty-gritty of the mechanism the FDA is using to prohibit these flavored pods or cartridges. However, if you want to know more about that, we have several resources on our website at publichealthlawcenter.org, and we have a section of our website called the FDA Action Center. And there's 2 webinars and a fact sheet that directly talk about this topic, and you can also contact me directly and I can forward those on to you. And so that's basically the overview of what's going on with flavors at the federal level.
Thank you, Natalie. So this is Natasha again. I'm doing another kind of jumping in here. I'm going to ask a couple of questions based on some of the things that have come in the chat box. So if you have questions during Natalie's overview, feel free to put them in the Zoom group chat, and we'll do our best to incorporate them into our question and answer portion. We'll also have time at the end for open question and answer. But Natalie, I was hoping that you can answer just some questions that I have for you to get some clarification, or maybe even just repeating some of the things that you mentioned earlier. So you had mentioned that there are some products that are very attractive to youth that have been a part of this kind of teen vaping epidemic, you know, a big part of the explosion in the teen use of vaping products, but that some of those attractive products aren't covered by the regulation. So what specific products are addressed by the regulation? You know, what about Juul and Sorin?
So just flavored pods or cartridges that aren't refillable are covered. So that's how Juul typically looks. And I think that Sorin actually is more of a self-contained product. And so it's possible that they are not covered. But I think Sorin has several products, so I'm not exactly sure all of the different systems they have. I think they do have some cartridge and pod-based systems, because I did get on their website and they had 50% off all flavored cartridges at the top of their website. So that must mean that they have something that they think is impacted by this law. But there's definitely a myriad of products on the market that are flavored, and we know that youth are using and interested in using. And so those are the only products that are covered in this specific mechanism that the FDA is using. Okay, so popular products like Sorin, that's some of their products, they have different products. Some of their e-cigarette products might be open and refillable and may fall out of the guidelines. Yes. Okay. So can you tell us again, when does this law go into effect? It goes into effect upon issuance. The FDA, for unknown reasons, probably because someone just forgot, didn't publish it in the Federal Register the same day that they issued the final guidance. And so there was some confusion about when the 30-day period is triggered, and the FDA, I just saw on their website, they updated their website that they are considering the publishing date to be the triggering of the 30-day window to sell off the product. So it's in effect as of January, what's the date today? 9th. January 7th, and then there's a 30-day window after that. So that would mean that on February 6th, products should no longer be sold in, these products that are restricted should no longer be sold. And then we have a question that I'm not sure, it might take some speculation on our end as far as how the FDA will work. But you mentioned that some of these products that are
that will be prohibited based on this regulation can apply and then enter back onto the market should that application go through? How long would an approval process like that take?
It's that's sort of an unknown question. There's products that have gone through other pathways for the same process that still haven't gotten approval or denial that have been on there for 10 years now or so. So it could take a really long time, but I don't expect it would take that much time. So the other thing that's happened recently is that several public health and health organizations sued the FDA about this issue. And so now there's a deadline for every e-cigarette, regardless of whether they're flavored, regardless of whether they're cartridges or pods or not. Every e-cigarette has to put in an application by March 12th of 2020, so in a few months. And then the FDA has a year to review those by court order. So at the latest, it would be March 12th, 2021 for the FDA to make final decisions on all of these products, including these ones that are removed now. But it could be earlier because I would expect the FDA would be trying to, as applications come in, do them as quickly as possible because there's no way they can make every decision on March 12th, 2021.
Thanks, Emily. So who is regulated by this guidance? So is it the retailers, is it the manufacturers, the distributors? Who's regulated?
This mainly impacts manufacturers because of the mechanism that the FDA is using to enforce this policy is about this approval process or this authorization process for reviewing products before they come onto the market. But the FDA does say in their guidance that retailers could receive a penalty for selling past that date as well, because they're selling products that are mislabeled or adulterated is the technical legal term for selling the product. So anyone that sells them could also be assessed a penalty if they are caught doing that.
Okay. And so it sounds like the FDA is regulating the industry or the retailer, the manufacturer, the distributors of the products. So what should a local licensing authority, local public health department, employee do if they see a product that clearly is in violation of what you've just talked about?
Then they should report that to the FDA.
So it's not on them to enforce?
Right. So they would then, the FDA would enforce this because the authority that the FDA is using is 100% within the FDA's purview of their authority. States and locals don't have the same authority. And so they would report this to the FDA and the FDA would do an investigation.
And then so for local public health departments, local licensing agencies, how should they be seeing retailers respond to this new law?
They should see probably heavily discounted these products, and then they shouldn't see them on the shelves at all, or even online. So it's not limited to any particular venue. So in vape shops, if vape shops do sell these cartridge or pods in convenience stores, online, if you see any of those places, you can report that to the FDA.
So basically what you're saying is that a city or a county in Minnesota, even if they don't have a flavored tobacco restriction, if they walk into a retailer, come March of this year, they just shouldn't see those products because of this FDA regulation.
Yeah, after February 6th, they shouldn't see these products. But like I said, it's just like these very specific, certain flavors, certain products. So.
And I have one question about that, these certain flavors. If you, we know the tobacco industry responds by creating all these new products. If someone were to see something that was like cherry menthol or vanilla menthol, these mixed flavored products that are clearly including flavors that are prohibited, is that a violation of the guidance that the FDA has put forth?
I would say yes. The FDA unfortunately, in their guidance, did not actually define what flavored products means, which we have known and is really a really large oversight in our opinion, because we've known by working in local communities in Minnesota and other local communities across the country who have implemented flavor restrictions that the definition of flavored products is very, very important to try to ensure that the industry doesn't do things like that, or even just not cherry vanilla, but you just have cream or like white vanilla or white, not cherry vanilla, cherry menthol, or you have like blue menthol. And everyone knows that's blue raspberry menthol, but they don't have that flavored on the title anymore. So the FDA just says flavored, and they don't actually define that. So it's going to be part of how the FDA will have to figure this out.
Great. Okay, so we have a couple of questions about kind of the FDA process and the timeline of things and how that can obviously be a little confusing. Does the FDA team on the Public Health Law Center website have more information about the kind of the process, the application, market application process that you were going over earlier?
Yes, we have more resources, and our most recent resources that we'll talk about these things are in the FDA Action Center, and I think we have a tab at the bottom that says recent resources. And there's a fact sheet and there's 2 webinars that really explain this a little more. But if you can't find it or you still have questions after perusing that information, you can feel free to just email me directly and we can let you know.
And on the website, does it have any information about how to report any violations of, you know, like the type of guidance you're talking about to the FDA?
I'm not sure if we have any resources that specifically say how to report to the FDA, but if you reach out to us, we will let you know how to, and I think that's a good idea, so I will also suggest that we come up with something that is easily accessible for people to report to the FDA. Great.
Thanks, Natalie. And I think just based on time, we're going to move on to do an overview of the recent federal tobacco 21 legislation. And Natalie, I understand you have a kind of an overview prepared on that. Again, we'll do some structured question and answer. I know that there are some questions that we haven't been able to get to for flavors, and we will do our best to follow up with all of you. Again, please remember that we do have a national webinar on both of these topics from the FDA team in the near future, where we'll go more into the weeds on all of these topics. So we'll do Natalie's T21 overview, we'll do a structured question and answer, and then if we have time, we will do, again, an open question and answer with the participants on the call. Natalie?
Okay, so let's dive into T21 and federal minimum legal sales age of 21. Okay, so in short, the federal law establishes the floor for the minimum legal sales age and is now illegal for retailers to sell tobacco to anyone under the age of 21 in all states, all U.S. territories, and all tribal reservations, including Minnesota. So that's the shortest takeaway that we can take away from this. And I know it's been very confusing, so I'm going to try to talk through some of the confusion, and we can also hash it out in question and answer. So what that means is if a community hasn't raised their minimum legal sales age to 21, and a retailer sells to someone aged 18 to 20 in that community, it is still an illegal sale, but is only a violation of federal law and not a violation of the minimum legal sales age provision in the local ordinance. That might kind of seem like a technicality, but it's something that you all experience every day, this concept that you and everyone in any particular community have sort of layers of laws that you have to comply with. You have local ordinances that are very specific. Then you have state law that you have to comply with too. So even if there's a crime that doesn't appear in your local ordinance, but it appears at state law, if you violate that, you've broken the law. And the same is true for federal laws as well, as being the highest, most superseding law. So the concept here is that you won't violate federal law, and you won't have violated the local ordinance, but that doesn't mean that the sale was legal, because a state or a local ordinance couldn't say, no, 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 in our community, you can sell to 18, 19, and 20-year-olds. That's not possible. And we kind of experience this a lot, even in our local tobacco control ordinances. So if you've ever worked on an ordinance that you saw was like 20 or 30 years old, and we said, hey, here's all these state minimums that this local ordinance doesn't have. It didn't mean that retailers in that community didn't have to comply with those state minimum requirements. It just meant that the local ordinance didn't yet reflect those. And so if your local ordinance didn't say you couldn't sell products that weren't in child-resistant packaging, even though state law requires that in your local ordinance, it didn't mean that in your community, retailers could sell products outside of child-resistant packaging. It just meant that if they did that, they weren't necessarily violating that specific provision of the local ordinance. Hopefully that makes sense. Feel free to ask questions and we can give more examples. So the main focus for local public health and local governments should be on enforcing their own ordinance, and they're not tasked actually with enforcing the federal law or explaining to retailers how to comply with the federal law. Retailers have a myriad of federal, state, local ordinances outside of even just tobacco control. There's lots of laws they have to comply with at lots of different levels or layers of government. And if they need help understanding what laws apply to them, they should get their own legal counsel. They can't expect local public health or local governments to be able to explain this to them. That's their own job to figure out how to comply with the laws that apply to them. It might be a community's instinct to update their own ordinance in light of this change, and that makes a lot of sense. But this should not be rushed, is our second main takeaway, is please don't rush the process. Oftentimes communities will attempt to quickly make changes, and that might lead to imprecise drafting that ends up with conflicts that can't be resolved, or you might miss other changes that we mentioned, like you might not have something about child-resistant packaging in your ordinance, and that's another change that probably should be made to reflect the state minimum requirements and federal law. So it does not have to be rushed. It should not be rushed, and you can take some time to thoughtfully approach this. So while the community is carefully considering its approach to updating the ordinance, and in the meantime, many of, if not most of Minnesota communities have specific language in their ordinance that says that any violation of federal or state tobacco control law is a violation of the local ordinance as well. So before I was saying you don't have a provision, so you would assess a penalty against the retailer based on the specific provision. Before I said the provision about the minimum legal sales age in the local ordinance, if it's 18, and they sell to a 20-year-old, is not something you could enforce. But if you have this other provision that says any violation of federal or state tobacco control law is a violation of the local ordinance as well, you could enforce that provision of your own ordinance. And that's sort of I wouldn't recommend that as a long-term approach necessarily, but it is in the meantime, while you're trying to make the updates to your own ordinance or taking the best approach to make the updates, you could, if you're getting complaints that a retailer is not abiding by the federal minimum legal sales age of 21, you can enforce that part of your ordinance against the retailer. And it will likely reduce confusion in the long term for a community to go ahead and consider updating their own ordinance to reflect the federal change. But it's important to note that that's not as simple as crossing out 18 and inserting 21. There are several changes that should be made to ensure that it's not conflicting provisions and that make sure that the whole thing is clear and consistent. And we help jurisdictions or communities draft those ordinances, and we're happy to do that to make sure that the change is reflected appropriately and precisely, and that we can also review the ordinance for any other necessary or desired changes and make suggestions that way as well. So I'm hoping to clear up some of that confusion. And so then there was also some confusion about when this law went into effect. And that's because Congress directed the FDA to make updates to its regulations at the same time as making this change to the law. And it's understandable why that caused confusion. But despite the fact that the FDA does have to update its own regulations through a rulemaking process, Congress also made it clear that the minimum legal dosage was effective immediately. So it's true that the FDA will be going through the rulemaking process to make those updates, but it's immediately effective that it's 21 everywhere. And the other thing to note, the other sort of question we got is, should we wait for the FDA to make those rules before we update our ordinance? And we don't see any reason to actually wait for that. The most likely outcome is that the FDA will just make these very specific changes that Congress directed them to make, which is really just limited to enforcing 21 through their compliance check process and requiring that same change for SINAR checks. And then now the looks like age, if they look a certain age, you don't have to, over a certain age, you don't have to check their ID, is going to be 30 instead of 27, which we support and think makes sense anyway. And 30 seems like an easier age for anyone at any time to check an ID and kind of think how old someone is. But one of the main reasons also to not wait for the FDA is that the finalization and the implementation of their process is likely to take about 270 days. So that means that if the community waits on the FDA, they could be waiting until September to make any changes to their own ordinance. And that takes, that's going to be a long period of sort of confusion if you're waiting for that. It's also true that this federal change may lead to state changes, and I expect that it will in most states. Last session, it seemed that the state would increase the age to 21 and also remove purchase, use, and possession penalties, or PUP penalties as we talk about them. And this is a possibility this year as well. And I want to say that our model policy for jurisdictions that we put out and that we use when we're helping answer questions about your your ordinances is thorough and forward-looking. So if communities choose to move forward prior to the FDA making regulations and prior to any state action on T21, adopting our model language is very likely to result in an ordinance that won't need to change, even after the FDA promulgates rules and the state passes legislation, because we have an ordinance that has any of the expected changes, or our model language anticipates those changes. So that's basically my overview of Tobacco 21. I do want to say that we have 2 blogs up on our website addressing these 2 topics, and they are in the FDA Action Center under recent resources. And you can feel free to go ahead and forward those to anyone that you get questions from, and see, just say, here, this is what you should know about this. And if you have other questions, you could direct them to us, or you could try to answer them or whatever. But hopefully the blogs will help answer a lot of the questions, and you could just forward that on and won't be as inundated with trying to come up with answers to questions. And then, even though I explained that I didn't explain all the nitty-gritty of the details of Tobacco 21 or the flavor action, I do want to promote and plug that we will have our FDA team's going to be doing a webinar on Wednesday, January 22nd at 1 p.m. That you can sign up for. Is it up on the website yet, Stephanie?
It will be this morning.
It will be this morning that if you go to our website and go to webinars and then upcoming webinars and click on that, then there'll be a link there to sign up for that webinar if you do it this afternoon or later. So look for that.
Great, thanks, Natalie. This is Natasha again, and I'm just going to ask a couple of questions and answers. We also have Rachel Callanan, another attorney on our team, with us. And so feel free, Rachel, to supplement Natalie's answers or jump in and also provide some information based on the conversations you've been having on this action as well. So I want to talk about federal T21, I do. But I want to just take a step back for a second because I feel like there are a lot of people in Minnesota who are working for local governments, like local public health departments, local licensing authorities, who are like, what am I supposed to do? I'm supposed to enforce this federal law. You, Natalie, really broke down this idea of who enforces what. And so in this particular situation, we have local government, state government, and federal government. And now we have this federal T21 legislation that's in effect. You also mentioned the fact that there are these local licensing ordinances, these state youth access laws, and now this federal T21. So when it comes to local licensing agencies wanting to enforce this federal minimum legal sales age, explain again how they could do that by enforcing their local licensing ordinance.
Right, so if you already have T21, then you're just enforcing that provision of your local ordinance that says that no one under 21 can be sold to against the retailers. And then if yours says 18, then what you are doing, if you need to be able to enforce it, like if there's a retailer that you know is breaking the federal law, you can report it to the FDA the same way that I was talking about before. And then also, you can look in your local ordinance and see if there's any provisions that would allow you to enforce it under your local ordinance. And so many of the local ordinances in Minnesota, because this has been part of our model language for a very long time, have a provision in their ordinance that says something like any violation of federal or state tobacco control law, like sales that are associated with that, is a violation of the local ordinance as well. So you could reach out to us and ask us to look at your ordinance and see if you have that, and we can explain to you if you do. And so you could enforce that specific provision. But that's the most important thing to think about, is that when you're thinking about what you can and can't enforce, as a local government, you can only enforce your local ordinance. So if it's there, you can enforce it, and if it's not there, you can't enforce it.
So basically, if somebody says, is it true that in Minnesota, the minimum legal sales age is now 21? If somebody says, no, that's not true, the minimum legal sales age in Minnesota is not 21, it's still 18. That's accurate, but that doesn't mean that the minimum legal sales age for the entire country is not 21 based on federal law. So we have state law, which has not yet changed, and you might have a local ordinance for a city that hasn't done T21, and that still might not have changed. So it still is true that the state law and the local ordinance might be 18, but that doesn't mean that it's legal in the United States, even if you're in, New Hope, Minnesota, that it's okay to sell to a 19-year-old.
Exactly. The legality of the sale is not related to what level of government law you broke. So if you break one level of government law, you've broken the law and it's a legal sale.
Thank you. Okay, so let's go back to the actual law itself. Can you tell us again, when does this law take effect, or when did it go into effect?
December 20th, 2019.
So it is in effect right now?
Yes.
Okay. And what products are covered by the law? Like, for example, cigarettes, e-cigarettes, but what about pipes and rolling papers and other like tobacco-related devices? Are those also prohibited for sale to people who are under the age of 21?
Hi, Natasha. This is Rachel Callanan, everyone. I'm chiming in because I actually did answer this question for someone recently in Minnesota. And the answer is that the law does cover the actual tobacco products that contain tobacco, but it does not cover, so the minimum legal sales age of 21 does not cover under federal law that paraphernalia that does not contain tobacco. So rolling.
That isn't made or derived from tobacco.
Right.
Yeah.
And so those, like a glass pipe or a, paper, rolling papers, things like that, that do not, are not made or derived from tobacco, are not included in this minimum legal sales age. And so that may be very different from state law, or your local law, because in Minnesota, tobacco-related devices that fit that definition are not allowed to be sold to persons under age 18. So that law is still in effect. So that is unchanged. So hopefully that clears that question up.
And Rachel, when you say rolling papers, something like a blunt wrap would be covered?
If the blunt wrap contains or made it derived from tobacco, yes, that would be covered under the federal minimum legal sales age of 21.
Okay, great. So Natalie, you mentioned the jurisdictions that are covered by this federal T21 law, and I have a question. Can you go up, Stephanie? Hold on, wait. Go back down. Down. Sorry, 1 second, everyone. Okay. So you're talking about where the federal T21 applies. What about on tribal land?
Yes, it applies on tribal land.
Okay. Do you have anything else to say about that?
And I think what the specific question was, if the retailer is licensed by the tribe, does this law apply to them?
Yes.
Okay. All right. So what, I just want to clarify, if you could just tell us again, this federal T21, as it stands right now, regulates only the sale of tobacco products and not the purchase, use, and possession of the products. Is that correct?
That's correct. And the federal laws never address the purchase, use, or possession. It's never been a requirement of federal law to penalize youth for purchasing, using, or possessing. So that's never been something that they've done, and so this law didn't impact that because that's not something that is illegal at the federal level ever.
So does the federal law apply just to sales or to the kind of like retailer, distributor, or does it also apply to people who are, illegally procuring products on behalf of a person who's under 21?
Just the retailers.
Okay, thank you. So,
but like with the condition that the same with the provisions that are related to that at state law or in your local ordinance, even if they say 18, then it's enforceable for anyone under the age of 18, just not for 19, 20-year-olds.
Right.
18, 19, or 20-year-olds.
Because like you said, it regulates the sale and not necessarily somebody who's illegally purchasing on behalf of them. It's not regulating purchasing at all, even if it's being done with the intent of giving it away to a young person.
But many of the state laws and local laws do address that, and if they're 18, then it's still enforceable for the same category. Nothing in the federal law prevents jurisdictions from having additional or more protective provisions in their laws.
Okay. I just wanted for the participants on the call, if you wanted to look at the language that Natalie was referring to in our model that provided this kind of violation of any law, federal, state, or local, to also be a violation of the local ordinance, it is section A, Section 6, paragraph A, number 4. If you look at our city, model licensing code, it's on page 14, section 6, paragraph A, letter 4. And we can send this out in a follow-up email. And again, please contact us if you'd like us to review your ordinance to see if that language does exist. But that is a way for you to cite retailers for violating the local ordinance due to a violation of federal T21. So Natalie, you mentioned that this is an opportunity for communities in Minnesota to look at their ordinance to see if maybe they want to make changes so that things are really clear there. You know, so if they have questions about federal T21, if they have questions about the flavors, they could go ahead and update their ordinance just so that it's comprehensive, it goes beyond, and it is clear for retailers, for local public health, it protects public health, but that this shouldn't be a rushed process if they decide to go this route. Mm-hmm. If they were to do that, would they need to give notice to retailers if they were going to update their ordinance to conform to federal law?
My reading of the state law is that yes, you would go ahead and give notice. This is a 30-day notice, because if you're making changes, then you go ahead and make a notice that there's not exemption if it's sort of just complying with federal law. If you're making changes, you go ahead and give notice.
And Natalie, will the FDA be developing materials for retailers or, you know, any other entity and guidance on this?
I expect the FDA will develop materials, but I'm not sure that they will do that before they get through with the rulemaking process. So maybe they will get inundated with questions as well and go ahead and do it, but oftentimes the way the FDA works is that they want to get all of their ducks in a row before they would develop materials and resources. And so I wouldn't expect to see resources until September, when the process is finalized, unless they are able to finalize it more quickly than the maximum amount of time they're given.
I want to hop back into this conversation about local governments in Minnesota really quick and talk about cities that don't have Tobacco 21 yet, but what they should do if they have this kind of language that any violation of federal law is a violation of the local ordinance, how they would go about compliance checks if they don't have T21. And if you don't mind, Natalie and Rachel, I would be fine kind of commenting on what our experience has been on this. Typically, so state law requires that cities and counties in the state of Minnesota do at least one compliance check per year with a 15 to 17-year-old, which means that a city or a county would be required to at least enforce or do enforcement on a minimum legal sales age of 18, right, with a 15 to 17-year-old. State law does not require a city or county to do a compliance check with an 18 to 20-year-old, nor does it provide flexibility for the city or county to do a compliance check with someone of any age. It specifically requires the compliance check be with someone between the ages of 15 and 17. However, jurisdictions in Minnesota are welcome to do as many compliance checks as they can, given their resources and limited capacities. And so if they have this language about violations of federal law also being a violation of the local ordinance, and they only in the ordinance require that the licensing authority or local law enforcement do one compliance check, that doesn't mean that they can't do 2 or 3. Typically, the language that we see in these local licensing codes just set a floor on the number of compliance checks that they do. They don't set a cap. And so they can go ahead and do another compliance check if one has already been done, you know, this year or in the duration that is required, and they can still, again, with that provision, do a compliance check to ensure that there is not a violation of federal law, thus violating their local ordinance because it has that provision. that a violation of federal law is also a violation of the local ordinance.
But with the clarity that if you do that check, you still have to do the 15 to 17-year-old check, and until and unless state law changes. And that might change at state law if and when the state changes the minimum legal sales age to 21 as well in their law. But
Absolutely.
in the meantime, you don't want to run amok of what the requirements are at state law, so you should be still doing the 15 to 17-year-old check within the time period that it states in your ordinance.
Natalie, I want to talk about the federal T21. Does the law allow grandfathering of anybody who maybe is already 18 or was 18 right before the law passed, or any military exemptions, so exempting people who are currently on active duty for if they're under 21, or is there no grandfathering and military exemption?
So the way it works is there is no grandfathering or military exemption. And so California is sort of like the most common place where there's a military exemption. If you're in California and you're military and someone sells to you with your ID and your military ID and you're 20 years old, they haven't broken state law, but they have broken federal law. So it works the same way that we're talking about, this sort of layered idea that there's lots of different levels of government and laws you have to comply with. And so it works the same way, that there's no grandfathering in the federal law and there's no exemptions of any kind in the federal law. And so if you were in adherence to state law or local law, but you broke federal law, you're still breaking the law. It's still an illegal sale.
Okay, so I don't think that, Minnesota communities are very much public health oriented. Very rarely, if any, adopt grandfathering or military exemptions, but if one did exist, that same thing is true.
Yeah, and if you were working on it now, you could not, if you adopted a policy that had that, you would just be, it wouldn't be in compliance with federal law. So it's not something that, it's not an exemption that people can use if they're living in a place that has that exemption already. It's still an illegal sale. And if you are adopting a policy post this, this Tobacco 21 with no exemptions at the federal level establishes a floor, and you cannot make exemptions, or you can't change the age to something lower.
And so with federal T21, does it establish a minimum seller or clerk age?
No.
Do you anticipate that could be included?
No.
Okay.
I really, really think, this is a kind of a convoluted question, but in the sense of like the grand scheme, if you think about the political climate, all the things that sort of are happening at the federal level, a lot of this comes down to politics and how things happen. And so I think that you won't expect to see the FDA do anything really extra in this regard. They're going to do what Congress told them to do, and that's what I think you can expect to see, is that they're going to change the age to 21, they're going to change the looks like age to 30, they're going to update everything for sign-out requirements and for their own compliance checks, and that's what you're going to see. I think that's the most likely outcome. I don't expect that minimum clerk age will be established.
Okay. We're just looking to see if we have any other questions.
The penalty if they
No,
don't do it.
keep going. Down. Okay, so when you're talking about, you mentioned the age 30, so, I think you were mentioning kind of age verification. Can you just talk about the, what are you referring to when you're talking about the FDA increasing blank from the age 27 to the age 30?
in the law, there's a provision that you don't have to check an ID if someone looks older than a certain age. And right now in the federal regulations, it says you don't have to check someone's ID if they look older than 27. And that's going to be changed to 30 because 18 plus 3 is 21 and 27 plus 3 is 30.
And then I just wanted to also mention that the Minnesota Department of Human Services has information on penalties, federal penalties against retailers if they violate compliance checks through their Congratulate and Educate program. Again, the federal penalty for retailers is something that would not be enforced by a local licensing agency, but we can provide that information at another time if you'd like. We don't have that much time here. I want to make sure to leave MDH some space to summarize kind of the conversation.
I also can say we saved these questions, right?
Mm-hmm.
And so I see there's some sort of specific questions about vending machines and things like that I can flip through and I can get back to you. You can feel free to email your question to me directly and I can answer those since we're sort of running out of time. But quickly, the one is that the FDA does compliance checks. They do controlled buys with youth, and then they also do compliance checks called advertising and labeling, and that's when they sort of look for all those other things like whether products are not, whether they're misbranded or mislabeled, and then the retailer can get a penalty for that as well.
Cassandra, we wanted to open the line to you. What we've been doing is just answering questions that people have put onto the Zoom group chat versus opening up the phone line for questions. But I just wanted to leave some time for MDH to summarize or make any final points. And if you wanted to open up the line for questions, we can stay here beyond 10 o'clock as well.
Okay, so here's what I think we should do, because I think the way we get clarity is through conversation like this, but we've sort of run out of time. I think at this point, we can carry this conversation forward to our point of sale call next week. We can dedicate that call to more Q&A, and for those that are unaware what that means, so we have it's primarily for anyone working on point of sale strategies through an MDH grant, get together on a monthly basis to kind of talk through specific local, state, or federal regulations and sort of the progress made at the local level. We can carry this forward. If you're interested in participating in that, the point of sale connect call is posted on Basecamp, so you can dial in. We can carry the conversation forward. In the meantime, between now and then, we'll continue to update the Q&A based on what's been in the chat and also the emails that we're getting. Natalie, you have volunteered to take questions to your email directly. So if you could, sort of collate them and we can update it. I don't know if you're going to be doing any updates to your blog that you mentioned at the beginning that kind of lays out the overview of both of these new regulations. But that's a possibility. We can continue to brainstorm how to get this information out to Minnesota Public Health.
Yeah, and I guess maybe we could also pull the questions that didn't get answered here, and I could just openly answer them on Basecamp too, in a post.
Okay.
So I mean, if people sort of have the same questions, I can try to answer all of those as best as I can.
That's a great idea.
Yeah.
Let's use that. Okay. So we'll continue to collate all the Q&A that we're getting, and we will put it on Basecamp. Again, so MDH doesn't have the jurisdiction over the implementation of these. Formal communication will come through the authorized entity. So we are not planning to create any handouts in terms of how to communicate this with local retailers. We don't, that's really not our jurisdiction, and we really defer to that authority. And so just hang tight on that. Like Natalie said, those things will probably be coming out at their earliest convenience. So in the meantime, we will communicate through Basecamp to try to sort through what it is that we know, and we'll utilize our TA providers to interpret what we can. All right. Okay, so it is 10:01. I'm going to go ahead and close the call. Thank you so much for joining, and look for Basecamp postings, and also please join us on the point of sale call next week.
Thank you, Cassandra.
Thank you so much, PHLC.
You're welcome. Bye.